In this short video, we will provide human resource professionals and managers basic information about medical leave and the various kinds of medical leave that there are so that you can do the best you can for your employees and also stay within the law. When an employee comes to you with a request for medical leave, it's really important that you listen to what they're asking you, and then if you have a human resources department or manager, that you send them directly to that person. It's the responsibility of the HR department to determine what sort of leave the person's asking for. Leave involves complicated federal and state laws which can be hard to understand and hard to interpret.
There are many types of laws and issues that affect medical leave, all of which are vastly different than company non-paid and paid time off. The FMLA is a federal law that provides 12 weeks of job-protected unpaid leave to care for a variety of situations, such as the birth or care for a newborn child, to deal with a family member with a serious health condition, or to rest and recuperate from your own serious illness. The ADA is a federal law that requires employers to provide a reasonable accommodation to qualified individuals with a disability, unless doing so would cause an undue hardship on the employer. Another thing to consider is short-term disability insurance, which typically ranges anywhere from 90 days to a year and is provided by the employer or paid out of pocket by the employee. That insurance covers a portion of the employee's salary, and working arrangements vary from state to state and policy to policy. Workers' compensation insurance is required by state law, and it's an insurance policy that covers employees who are injured on the job. The protections vary depending on the nature of the incident, how it occurred, and other factors.
Before you can determine what type of leave is the best fit for your company and its employees, first you need to determine whether the company is a covered entity and whether the individual requesting leave is an eligible employee. One of the most common types of leave is FMLA. An employer is covered if it has 50 or more employees working within a 75-mile radius of where the employee requesting leave works. An employee is eligible for FMLA leave if he or she has worked at least 1,250 hours for the covered employer in a 12-month period immediately preceding the leave request. If either the company or the employee do not meet these specifications, you do not have to provide FMLA leave. You may, however, wish to offer your own medical leave policy, but there is no legal requirement to do so.
In this segment, we will focus on the FMLA, which can seem complicated to many, even experienced HR professionals. Employees may take FMLA leave all at one time, in 3 or 4 week blocks, or even on an intermittent basis or with reduced work hours. For example, someone with migraines doesn't really know when they're going to occur, so they may take off on an intermittent basis, which is very frustrating for HR managers to deal with. In fact, frustrated managers may complain to HR because they just don't understand what type of leave is allowed under the FMLA.
While many of you are familiar with the FMLA and other medical leave, we still want you to be aware of the pitfalls that are associated with it.
Under the FMLA, there are 2 types of lawsuits: retaliation and interference. There are scores of them being brought right now, and they're a big issue for companies. For instance, if you don't grant FMLA leave to someone who's entitled to it, that employee can sue your organization for interfering with their FMLA rights. Or if you give that employee leave, and they later come to you saying their manager or co-worker is retaliating against them or treating them poorly, they can sue your organization for retaliation, and we sure don't want that.
With constantly changing federal laws, guidance, and regulations, it's critical that you stay up to date on what's going on in the employment arena. Our team works on everything from advising you about hiring and firing to assisting you in responding to a charge of discrimination or harassment, all the way to a lawsuit. If you have questions or would like us to conduct a training for your team, for your executives, your managers, we would be happy to help you.